Does the Department of Education have integrity? The dream. The pursuit of happiness. Paying for the dream triggers infectious corruption. The U.S. Department of Education has had 12 secretaries since its birth as a cabinet-level department in 1980. 6 secretaries of education have presided over a student loan program that lost constitutional protections starting in 1998. What were these secretaries truly swearing to? Six secretaries of education have collected on student loans, including through non-judicial, administrative, wage garnishments, which led to the loss of constitutional protections. 6 of the 12 secretaries of education have presided over a federal financial product that lost constitutional protections. 6 secretaries of education have marketed and sold a national financial product that lost constitutional protections. 6 secretaries of education have policed a financial product that no longer has competitors and gradually lost constitutional protections under their leadership and protection. We could hear the Biden administration beg the Supreme Court for student loan debt forgiveness rights to no avail.
If they thought it was permissible to seek relief under the Education Act, correct?
That's correct. It's a totally different source of authority. If they want relief under the Education Act, there are provisions where they can file a petition for rulemaking and ask for that relief right now. And it's not as though these are mutually exclusive sources of authority. The Education Act is not directed to national emergencies. It's not. It's an independent source of authority here, unlike the HEROES Act, which is the action they're challenging that's specifically focused on this agency, this national emergency situation.
The court agreed with this attorney. Secretaries of Education can and must use the Higher Education Act to forgive student loans. Why won't the Secretaries of Education use the Higher Education Act to forgive student loans? SallieMae was created in 1972 and became private in 1997 to promote bank-issued student loans backed by government assurance, the privatization of student loans. Banks created questionable financial products that led to the 2008 crash. Colleges greedily increased tuition knowing banks were excited to sell and maintain student loans. Foreseeably, this led to lender excessiveness. Lender excessiveness killed the pursuit of happiness. Now, the Department of Education owns most of the student loan debt. Banks could not compete with the federal student loan product without cheating. On average, Black, non-Hispanic adults in the U.S. also hold higher student loan debt balances than borrowers of other races. Instead of allowing for the traditional pursuit of happiness with or without student loans, the American dream, We are headed towards a third generation subject to, controlled by, this student loan program without constitutional protections. Courts allow the U.S. Department of Education to confiscate money for student loans without judicial review through the administrative wage garnishment. Not very long from now, there will be no more money to confiscate. The moratorium on collection had to start with COVID. Student loans are a new form of indentured servitude. Indentured servitude is a form of labor in which a person is contracted to work without salary for a specific number of years. The contract, called an indenture, may be entered voluntarily for purported eventual compensation or debt repayment, or it may be imposed involuntarily as a judicial punishment. Student loan borrowers are expected to work for the life of the loan. The loans are entered into for unknown eventual compensation for debt repayment. Repayment for life is imposed as a judicial punishment without proof of hardship. The government's willingness to lend without a known salary source for the borrower that would serve to repay the debt is considered an entitlement, like voting rights. However, administration of the federal government's financial product drove up tuition and fees, effectively removed constitutional protections, and eliminated safe financial choices and financial flexibility. Student loan borrowers are pledging their retirement money to pay off the loans. Their retirement money is no longer eventual compensation. Americans are bound to the Department of Education in exchange for finishing their education like indentured servants or bound to their employer for passage to the U.S. Seeking passage to the U.S. to achieve the American dream is equivalent to seeking to finish your education. However, America's vast accumulated knowledge must be handed down to us for our safety. Indentured servitude only ended about 100 years ago, 1917. That habit of lenders thinking how to build wealth, which cheats the servant, appears to still exist for student loans. But it makes no sense for public servants to cheat the public to control student loans, which is a competitive government financial product. Student loan privatization did not work, and so ended in 2010 by cutting out the middleman lender banks for federal student loans. But government control is not working either. Protections put in place to control lender greed have failed. Without respecting the bankruptcy protections in the Constitution, all efforts to control lender greed will fail. All efforts to remove the right to a fresh start create excessiveness. Excessiveness maintains uncertainty. A strong dollar requires certainty. Debt soared after the 2010 solution, so you cannot safely pursue happiness before you pay off your student loans. There is no safety net without constitutional protection. Wall Street depends on student loan debt. Student loan asset-backed securities are issued based on student loan financial products. Risk-taking continued. And investors can anonymously discuss their assets and transactions free from unwanted public scrutiny. When and why did student loans become non-dischargeable in bankruptcy courts, creating indenture? We jeopardized our safety in exchange for collecting on student loans for the life of the doctors and the dentists that we turn to in pain. The people we turn to when we are in pain are deep in debt. They must create a vicious cycle of increased expenses passed on to us so they can pay back their loans. We lost a lot of doctors during the COVID plague all at once. The financial squeeze is getting tighter, and the COVID plague is still here. Who made student loans non-dischargeable retroactively and with no statute of limitations? At first, it was Congressman Alan Ertel from Pennsylvania, though only 1% of student loans were wiped out by bankruptcy protection then. Then, gradually, more legislators. Alan Ertel argued that we are discriminating against future students because there will be no funds available for them to get an education in the legislative history of the 1978 Bankruptcy Reform Act. In 1998, his disinformation prevailed. When did student loans first lose government protection? 1976. We lost control of default rate reporting and accurate databases then, permanently. In 1998, when bankruptcy protections ended, a new financial product was created, the emergency consolidation loan. Banks were allowed to pay themselves off to create a new student loan. That is when borrowers had to figure out whether they had a federal or private student loan. Borrowers have not had a reliable database with proof of whether a student loan is federal or private. Student loans are treated as an entitlement, a right, like voting, but without constitutional protections. In law, an entitlement is a provision made in accordance with the legal framework of a society. Typically, entitlements are based on concepts of principle which are themselves based in concepts of social equality or enfranchisement. Is the student loan debt trap equal to an enfranchisement like voting rights? Is it like liberation from imprisonment or liberation from slavery? The bankruptcy provisions in the Constitution disabuse such notions. Now the courts have created a patchwork quilt of undue hardship tests. Student loans have no constitutional protections, effectively, because the Department of Education took the missing protections as a signal to protect the financial product and not protect the people. Now, borrowers are in debt for life. The 2005 Consumer Protection Act removed bankruptcy protection from private student loans too. So, Congress began to create forgiveness cutouts for essential efforts, like teaching. Teachers make us want to finish our education. And in July 2021, the U.S. Second Circuit Court of Appeals restored bankruptcy protection to private student loans following two other cases in two other circuits, Henry Crocker and Henry McDaniel, because the term educational benefit, as used in the bankruptcy dischargeability exception, was not broad enough to cover a private educational loan. No student loan database is policed, so collection after the moratorium will not be trustworthy. The public will be cheated based on untrustworthy databases. Borrowers have no reliable and trustworthy database they can take to court as evidence of servicers' actual activities. The Department of Education requires borrowers to establish whether they have federal or private loans without a trustworthy database to turn to. Disinformation. The department garnishes without a reliable database and does not lift a finger to assist borrowers because the Constitution is never applied to student loans. The Department of Education operates in darkness. Lawyers for borrowers struggle to obtain a careful review of the facts. Not many lawyers know student loan law because borrowers are broke and the Constitution is not applied. So, borrowers don't know what questions to ask or how to find enough money to pay attorney's fees. Borrowers witness constant computer overrides. And now, the Department of Education's hearings are held in secret. When the people cannot see how the government is spending the money, the people are not strong. Therefore, the student loan product is the most dangerous financial product in America. People who want to finish their formal education have to be debt trapped the more they learn and want to learn. Warnings about the debt trap have been ignored by too many for too long because few could see that student loan debt traps you whether you have student loans or not. Voting hasn't helped. So, is the Department of Education trustworthy?